This is the biggest mistake people make when doing beneficiary designations on their accounts. I'm Taylor Kaspar, Minnesota estate planning attorney. I help parents make empowered choices so that if they couldn't take care of their minor children any longer, the right people would do so. So this is the biggest mistake people make when they are making beneficiary designations in their retirement accounts, their life insurance accounts, their investment accounts, their bank accounts, their house, whatever it is. Anything that you can name a beneficiary designation on, people make this one big common mistake way too often, and it is this. They name minor children as their beneficiaries. That is a big no-no all day long. Here's why. I'm gonna tell you a little story. I have a client right now, and she is a fabulous individual, love her dearly, and she has two children, ages 15 and 17, and their grandfather died about a year ago, and he named the children as a beneficiary on some investments and other accounts. Well, he's gone. These two children are going to get these accounts, and they're two different kinds. They've got like $168,000 a piece in investments in cash, and then $245,000 a piece in inherited IRAs. So the company that holds these investments, cash, and these IRAs will not release the funds to the children because the children are minors, but the funds have to be dispersed within 18 months of the grandfather's death. Well, it's been over a year, so we're getting closer and closer to that 18 months, and they can't go to the kids, but they have to be dispersed. So what do we have to do? We have to go to court, unfortunately, right? Because there's nothing else we can do. So we have attended court, and we go to court, and the judge advises us that, yep, there's so much money that we can set aside in a restricted account, and what that means is the money will get dispersed from the company, put in this other account, and nobody can touch it for any reason at all until the children are 18 years old. And then when they're 18 years old, they get it all 100% outright. So her 18-year-olds, when the kids turn 18, they're each gonna get a check outright for $160,000+. Just here you go, good luck to you. Godspeed, right? The rest of the money, the $245,000 each, is going to have to be somehow dispersed or distributed into a conservatorship. That means this mother has to become the legal conservator of her own children, and each year she will have to provide the court with an annual account of all monies that come out of the inherited IRA into some other investment and vehicle in her children's name. She'll have to account for the transfers, any interest earned, any money spent on her attorney's fees, the bank fees, brokerage fees, any fees that get incurred. She'll have to account for all of that in these forms and on this online portal to the state of Minnesota. You are subject to audit when you do that with the state of Minnesota. And then the other thing is every year she will have to pay a bond in the amount of 1% for the money that she is the conservator of for her children. So she has to reach into her own pocket every year and pay 1% of $245,000 for child one and 1% of $245,000 for child two each year that she is the conservator of these children's estate. So if that's not terrible and horrible enough for you to understand why you should never name minor beneficiaries as the beneficiaries of your estates or of anything that you can designate a beneficiary on, then I don't know what is, because that sounds pretty not fun to me. So if you have questions about that or want to know the alternatives to what you can do when you're naming beneficiaries on your assets in your estate, if you do want the ultimate people to inherit to be people that are minors right now, well, if you want to know more about that, then after you've liked this video and subscribed to this channel, go ahead, pop down to the description below, book a 15-minute phone call with me, and I'm happy to get your questions answered.